next part of our program, the Q&A. There is a microphone in the middle. If there is anyone who would want to ask any question, please, yes. Please state your name.
Hello. Anyway, hi, I'm Ikari from Raptor. I'd like to ask about, recently DBM Secretary Jokno said that the President prefers CONAS because it is cheaper. So in terms of political representation, I guess, what are the possible implications of this then, choosing CONAS over CONCON? Thank you.
So it's a really interesting question, and I think what's interesting about your constitution is that it gives these two options, either for Congress to sort of become a constituent assembly or to have a constitutional convention. But actually these two bodies are not necessarily opposed to each other in terms of course you have the representation of Congress as a representative body also acting as a constituent assembly, but that does not preclude further participation. That is, you can have, and I'm not sure how this government will organize the drafting body, but you can have a commission that actually goes out and takes inputs from the public for the first draft. And you can also have the same commission after the draft has been drafted, sorry for the repetition, but after the draft has been drafted, bring the draft to the public so that they can comment on it. If this process is made in a transparent way, I think it would be very positive in terms of the legitimacy of the body as well as the legitimacy of the final product. So it is cheaper indeed because you already have a Congress and you don't have a constituent assembly. There are many things yet to be decided, also in terms of the terms of reference of this constituent assembly. What will it do? How will it work? Who will draft? What will be the mechanisms, not only of public participation but also of civic education? Because as we heard before, in the Philippines, not many people have read the Constitution because it's not accessible to everyone. So how will you make sure that everyone is actually on top of these issues and can actually give their inputs to this constitutional process? So, in very brief, I don't think that having a constituent assembly actually precludes broader participation, but it is a thing that still needs to be decided by the executive as well as by the legislative. Thanks.
No, I'm not an expert on constitutions per se, so I'll leave those to you.
I should probably, from my undramatic Finnish perspective, say that the con increases the drama, I should say, and con as probably may reduce it a little bit, but from a Finnish vantage point, both are very dramatic instances. So that's my only comment.
Actually, that's an interesting question. Right before the forum began, Professor Dr. Suksi and I were actually discussing these developments. Just 3 points on that question, and to add to what Dr. Fülscher already mentioned, I think we can look at it from three perspectives, or from 3 approaches. One is, in theory, because we indicated in our current constitution that these are the modalities available for both amending or revising, meaning changing the constitution in its entirety, that we have some faith that in either case, the result is something that we can own and accept at the national level, because we have decided in the current constitution that these are readily available mechanisms or modalities for amending and for revising. But number 2, I think the larger question, regardless of the choice, is the ability of either, the second point I think that's important to emphasize is, regardless of the modality, even if Congress sits as an assembly, they're exercising a power to rewrite the Constitution. It's not an extension of their legislative function or duties. So it's important to bear in mind that when they sit in an assembly, the expectation is that they will be engaged fully in the work of Constitution rewriting, and therefore qualitatively the outcome between these two should be something that can be submitted for ratification subsequently, and therefore owned or accepted in that manner. So that in theory is, our expectation over the availability of these modalities. But number three, I think the larger question between the two is, I think one of the reasons why there was reference to a convention at the beginning and throughout the campaign period is to isolate the work of that convention from political interests that would have already been established once we've elected the representatives in Congress. And I think the larger question around that is the ability, whether it's an assembly or a convention, to devote the attention that's required to constitution making and to make the process, for lack of a better term, inclusive, meaning it shouldn't be work that is given because there are experts and therefore can exclude the larger population from participating. And that's not why we would prefer a convention to another, meaning that we are assured of participation just because we've held special elections for delegates to the convention. So regardless of which modality, I think the larger challenge is to enable public participation in the process. And that's why earlier I mentioned it's going to be a challenge because information is very difficult. If we're beginning with a population which has not even come to read the Constitution that we're going to try to change, then we see the challenge ahead of us in terms of even beginning the information dissemination on what we're trying to do. Just in the forum held last Tuesday, the question was, everyone's talking about a shift to federalism, but maybe we're not even on the same page as to what federalism means. And it's an important starting point. And what processes can we put together in order for that information sharing and public discussion to take place. And then just let me close, especially for those who are very young with us today. This isn't also the first time that we've had exercises in the area of constitution making. I'm not even going to go as far back as the Malolos Constitution, but you have the 35 Constitution drafted by a commission, but with clear instructions to adopt as much of the American Constitution under the Tidings-McDuffie law. And then we actually had an election for convention delegates to revise the 35 Constitution, and which led to the very exciting and controversial submission for ratification of the 73 Constitution. Of course, for those who are upperclassmen, that would have meant reading the entire volume of the Supreme Court report annotated on Javellana versus Executive Secretary. So that's the future for my law students who are here. But we've had that experience. And during the forum, Ambassador Cruz, who was with us, spoke with regard to the politicization of the convention, notwithstanding the election of the delegates. That could be a signal for me too. And at that point.
Are there any more questions?
Maybe just let me add very briefly that the fact that the Constituent Assembly might be cheaper than the Constitutional Convention, I think that it very much depends on the extent to which the public participation process will work. Because the public participation process is also a very expensive thing. If it includes a civic education campaign, even more. And so this should be included in the calculations when deciding about one or the other. But yeah, thanks.
Professor Ferrer has a question.
in one of the Dr. Kimana Zulueta slide, you refer to the political parties as basic. I mean, the context of political parties actually being the ones doing the constitutional reform process. Of course, if the Constituent Assembly pushes through in our case, then we're stuck with some kind of that arrangement. And but if you look at I understand in our 1971 Constitutional Commission, one of the requirements to run as a delegate was not to be associated with any political party. And the CONCON resolution filed by Senator Chilon in the Senate, actually, and several other members of the House who filed similar resolutions for CONCON, but some of them have backtracked when the President backtracked.